talking about the judiciary, I request Shravan Giri Garu to give a speech and also tell about the solutions, how best we can improve the law.
Good evening to one and all. First of all, my heartfelt thanks to Dr. Kirti for giving me this opportunity, and all the dignitaries over here and everybody present over here. The one thing that we are here for today is not something which is very unique or something which is not very common. It is very common in every house. Earlier, when there was no awareness, it was a very rare case. Some used to disclose, some used to never disclose it, which used to lead to something that we never used to think about it. I would like to start, I'll go a little back, but very categorically I will go. There are two instances where family come together in excitement. One is when there is a marriage ceremony. And second, when there is a marriage discord. The first, when there is a marriage ceremony, what do we see? We are Indians, we have a culture. The family, when they go to see a girl, or else a girl family is coming to see a boy family, they just see the qualification of the girl and qualification of the boy, but at that time, one thing that is admired, that is the background of the girl and the background of the boy. This is something which is very common. घर कैसा है, परिवार कैसा है, लड़की कैसी, तीसरा सवाल होता है. So, this is something from where it starts. Now, every marriage, we are here, we are talking about Reformation in section 125, that is maintenance. Maintenance comes once the discord and the dispute has arose between two parties, that is husband and wife, and their family automatically gets involved. Today we are at Constitution Club of India. The first thing that I want to bring to the knowledge, the preamble of the Constitution of India. The preamble first of all says, am I on? I am? Yeah. So, the preamble, because of the phone, I'll keep it, sorry. The preamble of the Constitution of India says, I'll just take one line out of it. We the people of India do hereby gift this Constitution to ourselves. This is what the Constitution of India says. Nevertheless, let us not roll through each and every article. Article 21 of the Constitution of India says right to liberty, right to equality. Right to liberty and right to equality means today there are certain terms which are being generated by people to create diversified issues. The first thing that is supposed to be taken into consideration where your country is democratic, the foundation of your country is the Constitution of India. Article 21 says that you have a right to liberty, right to equality. Where comes the word gender equality? We all are equal. We respect our mothers and we assault our wives. Where does the gender equality and Article 21 or maybe the Constitution is being taken into consideration? At the very first, where we talk about the Reformation is supposed to be done in this year of 125. I'll come to that aspect on a very shorter note. First of all, Constitution of India should be made a subject in school. Let the children during their growing years, let them hear, read, learn and understand the foundation of our country. The very highly respectable book that we read and we all are abided by it, we are bounded by it, that is Constitution of India. Where every fundamental right is explained, where parliamentary right is explained, where each and every aspect, all the questions of your life, you will get an answer over there. Now, Article 125. Before I come to Article 125, I would like to demonstrate two phrases. One is a very highly respected Dr. Justice K.K. Iyer said in one of his judgment, law is above all, but if something which is larger than law is the life itself is the first step which gives birth to a law. Now in 125, where we talk about maintenance, there are three aspects in maintenance. 125. One, it says, the headline itself says that maintenance is for wives, children's and parents. Let us constrain ourselves within an ambit of 125, what exactly it says. Wife who is deserted, who is not capable of maintaining herself with sufficient means. I underline and I shine a light upon this thing because this is forming a part of this particular section. Second is disabled child, girl child or any child below the age of 18 who is unable to maintain itself, herself or themselves. Third is the procedure. It is a settled provision of law which is not only enumerated but enunciated in CRPC, which is the foundation of criminal law. It says any application made under 125 has to be on an interim basis, be decided within 60 days. The interim relief, any person who is aggrieved will move to the court. The interim relief has to be decided within 60 days. This is a settled provision of law which is not being applied or made into application on day-to-day basis in any of the courts of this country. Second, it says once the maintenance is passed and husband is not abiding to the order passed by the court of maintenance, in that case, there can be a distress warrant issued. That is 125 subsection 3. 125 subsection 4 says the law is seeing everybody with an equal eye. Any wife who got an order of maintenance and has failed to abide by the law till the whole process of divorce or getting separated is done, the wife is supposed to, and wife gets into any sort of adultery, then in that case the court has direction, court has discretion to reject the order as well. Now this is the settled provision of law. So far in 125, there have been several proposals made to the parliament. There has been several amendments also done. This law was incorporated and got into enforcement in 1974. 1974, the time, era and the situation were way different. Today we are in 2023. Considering that aspect, the word, as I highlighted, the word sufficient means. The sufficient mean clearly denotes on one particular aspect where the females were not allowed to go out of the house, they were not allowed to work, they were not allowed to do something that they like. 1974. And if in that situation they are being deserted out of a matrimonial discord, in that case, they have a right to move to the court for seeking their sufficient means. Today, education is provided to the child. Every child who is born is loved. And there are some unfortunates, those who are deprived of this thing as well. Let us come to the technical aspect of it. We are talking about reformation. The law is good, but it needs enhancement and amendment considering the today's time and today's era. The law clearly says the maintenance has to be provided. The law also says within 60 days the interim relief has to be given. The law says if it has not been abided, then in that case the person can make an application to the court and a distress warrant can be issued against the person. Now, distress warrant means this provision says 1 month police custody, 1 month judicial custody for disobeying 1 month's maintenance. This going through the custody does not mean that his 1 month maintenance is waived off. No, that is accumulated. Those accumulate and become an arrears. Now, second thing, in today's world, when we talk about maintenance, this particular statute, that is 125, the law says, the interpretation says, the jurisprudence says that interpretation of the statute has to be done on the face of it. Today we are deprived of this thing because initially, maybe sometimes back, some court might have not followed and a backlog started accumulating, just like the arrears which are accumulated in the hands of the husband. And today, that has become a big task to clear the backlogs. The interpretation of statute has to be taken on face of it. Today, it is contradicting. It is contradicting in such a manner that interpretation of statute is not taken on the face of it, but it is completely followed on an ambiguous ground. There are a lot of ambiguities. A wife approaching to the court, the first feeling that the court has, the lawyer has, that is she is wrong and what she is asking for, that is wrong. This mentality has to be eraded. There are issues. The issues is that when husband and wife, when they get married, they become husband and wife. They live a life. That life is something that she deserves to prevail throughout her life. Once the dispute arises between husband and wife, what happens? The wife is deprived of the same lifestyle that she was having. Husband has been supported by the whole family, and as I just used the word ambiguous. Ambiguous means what happens generally? The husband, where the dispute arises, what husband does, any property and every asset that he has in his name, he transfers in the name of his family. I have my lawyer friend here. They are very closely relating to it. So they transfer it in the name of their mother, father, relative, or long distance residing sister, brother, whoever. Now, this is the problem which we are facing. Now, why I am able to say all these things? Because I myself face these problems on day-to-day basis. Why these maintenance applications are pending and the settled provision of law, that is 60 days, is not being complied with? Because there is one worry point. We have to go into roots to understand where is the problem arising from. The worry point is starting of the day of every court, which has a jurisdiction of taking care of 125 application. The starting of the day of the court is decided on the basis of a cause list. The cause list is running in the per day matters which have been listed, that is 125, 150, or apparently sometimes it is 200 plus. One judge, one mind. Every party, those who are approaching to the court, wants to be heard at length. Humanly not possible. Hence, the board reaches at the most at 25, 35, or if somebody is lucky enough till 60, 70. This is where the problem is. For proposing the reform, I say first let us get into the roots. The roots are that the courts, first of all, the cause list, the daily matters are supposed to reduce it. Second, the interpretation of statute which has been embarked in it, enumerated, enshrined in it, has to be followed blindly. And if there is any person who is deprived of this thing, as on today also can move a writ petition before a high court. And if he is not getting a satisfactory results from there, he can challenge that thing in Supreme Court as well. From a lawyer's point of view, second, the domestic violence case, here we were talking about 125. The interim has to be decided within 60 days. The domestic violence case, the foundation says the whole application, the whole case is supposed to be disposed within 60 days. I have never seen any matter getting disposed in 60 days. For domestic violence, there are two approaches. One approach is, you move an approach, you either move directly to the court, or there are protection officers who are there in the police stations. The law says, reducing your grievance into writing, moving to the protection officer, after investigating, if finds that there is particular substance in this particular grievance, then the protection officer will move an application or his report to the court. I'll just take one more minute, madam. Just one more minute. So,
I just want to question, because the days are with live-in relations also.
Yeah.
Do you want to talk anything with regard to the live-in relations or only married wife?
See, live-in relation were never considered few years back. Now law has also covered that as well. Living in relation means it is as equal as living husband and wife. If you are living in the same house under the same roof, and any sort of dispute which arises, for example, there is an assault, there is an abuse, there is a taunting, yes, she can move for domestic violence. Second, 125, if she thinks because of something that she has faced, she is unable to maintain herself, yes, she can move under 125 for maintenance as well. So, living in relationship is as good as husband and wife, because both of them are consenting. It's a consensual transaction between both of them, and then they live together. So, coming back to the reformation which is required. On three aspects, reformation is required. First of all, the law which is in implementation and in enforcement today, that needs to have an addition. Many a times we have seen the parties move a grievance before the court, and that grievance has no backup. Now the backup means it has no material substance, and ultimately the court has to do a guesswork. How much should I pass a maintenance? She is saying his income is 12 lakh rupees per month. And the other side says, sir, I am getting in hand 85,000 only. How do I believe? This is an issue. So in that case, the reformation that I suggest and I advise, which is already one of the judgments passed by the apex court of the country, that let this thing be incorporated in the settled provision of law 125(1), that is, both the parties approaching to the court or defending has to give a complete disclosure of their assets and liabilities 6 months prior to the marriage. This will give a transparency and also a stability and also a forum and also a foundation to the court to pass a very dignified order, and this will automatically ease out the whole problem. Second is, any person, this needs to further be added, any person who has given the assets and liabilities and has falsely or deliberately concealed or suppressed any portion or material fact, in that case, on an application made by the adverse party, there is an open case of a perjury which can be filed against them. Third thing, if perjury is filed against that particular person, then there is a provision in IPC which is 193, producing false evidence or suppressing or misleading the court. In that case, the person should be penalized according to IPC. The punishment is 3 years. So this is the foundation. We have everything. The whole thing is that it has to be interpreted and implemented in the right way. The old laws that we have and which we are trying to make it applicable today has become ambiguous, because the ambiguity has taken a front step, and based upon that, the apex courts of the state and the apex courts of the country are forced to pass an order upon it, which becomes a subsequent law apart from the settled provision of law. So, my suggestion, I just elaborated that let both the parties give a disclosure so that the court does not have to do a guesswork. Second is, any person who has falsely approached the court or suppressed or concealed anything, that person should be prosecuted in a form of perjury. Third is that a penal section may be applicable on this thing. Let the person suffer custody. If you can play mischief with the justice, judiciary, then in that case, you are committing a further crime, and that too intentionally. So this is my suggestion, which is required as a reformation. Further, the learned MPs have made a very beautiful proposal. I've been listening to each and everything, and today I say that we are blessed. How we go to a mandir and we think, how do we connect to a God? So we talk to Pandits and somebody. Here we want a reformation in law, and we have honorable MPs over here. We heard them. They have taken a beautiful interest in the subject. We are blessed that tomorrow at least some movement can be done. And in an affirmation, today we had 3 MPs. Tomorrow we can have more than 100. And this law can come into implementation for a betterment in the society, where, again I repeat, Article 21 should be labelled and should be defined in a golden words outside each and every court. So this is my suggestion, and I took a little more time.
Because he has taken all the way, and also disturbing on and off that he is not well also. Can you suggest us? Can you suggest us? Can you come to virtual meetings? And he is taking all the pressure from us and also helping us in framing these amendments, what is a suitable thing and all those things. Now I request all the panelists to take our small gesture. It is not a felicitation. It is like taking your time and coming to us, and also it's an honor to all the sisters and daughters of India.